Welcome back to What's the Hazard? This is Doug. It is Friday, September 1st. August is just a blur. It's in the rearview mirror. How the hell did that happen? I don't know. We have some incredible guests this morning. I'm really excited, and we've talked about it. I've been kind of prepping these guys for the episode, but my good friend Randy Stevenson, my new friend Brian Moore, attorneys, Esquires with Baird Holm Law Firm here in Omaha. Man, it's great to have you. Thank you for being here.
We're glad to be here. Yeah.
People have been really excited to hear from you. Everybody is excited to hear from you when you are offering information about OSHA specifically, but we're going to talk a little bit more about workers' compensation today, which is a subject that is always there. It's always on the periphery of the safety and health work that we do. A lot of people have to do both. In fact, I think the systems are commingled oftentimes in businesses, but there are some distinctions and some misconceptions that I'd like to talk about. So we'll get to that. But first of all, I just have to satisfy my own curiosity. You guys both went to law school at the University of Nebraska.
Correct.
But you were not in the same class.
No.
A couple of years apart.
A couple years apart. Okay. Because Randy, you and I are basically the same age. You graduated from law school in the 80s.
85. Yeah.
85. So that would probably put us almost at the exact same age. Graduated from college at 82, then I'm assuming.
Yep.
And you just graduated from law school.
Yeah. I was born in 86.
Okay. So now we know who's who.
So
Okay.
I graduated from law school in 2015. So about 8 years out in practice now.
But you guys are both in the employment and labor group at Baird Holm.
Right.
Okay. So you're colleagues.
Yes.
And you're a partner.
That's right.
Wow. Good for you, man.
Thank you.
You get to be a partner that young?
Yeah. Well, he's a superstar.
Okay, good. I'm not even a partner in my own company, so I'm impressed. That's fantastic. Well, so first of all, just what does LLP stand for?
Limited liability partnership.
Okay.
It's just a business entity.
Okay. It is not a reference to law, the practice of law specifically.
No.
Okay. All right. I did not know that. And then Esquire, where does that come from?
I'm not really sure. I mean, obviously it comes from England.
It's an English term.
It's an old English term.
Okay. So does it refer to counselor or
barristers and solicitors?
Barristers and solicitors
in England would be called. Do you know any more about the origins?
I couldn't tell you anymore. I don't even use Esquire.
Okay. It's not on your card?
No, it's my mom likes to put it after my name.
I'm sure she does. Oh, my mom would love that. Yeah, she doesn't get that opportunity, unfortunately.
Yeah. I mean, on my cards, I don't have it. I mean, it's, some lawyers do it. I think they're kind of mad because as a profession, we've agreed in this country not to call ourselves doctor.
Okay.
Even though we've got doctorates.
Mm-hmm.
So.
But you don't refer to yourself as Dr. Stevenson?
No.
Something like.
No. I mean, if we were lawyers in Europe or a lot in other parts of the world, they use that honorific.
Okay. And you guys don't use the powdered wigs either, do you?
No.
Okay. Because I watch a lot of Netflix, and I really enjoy some of those British legal shows.
Mm-hmm.
Some of them are really interesting, and they use the terms barrister and some of the terms you mentioned. Very old fashioned, or at least old looking practice of law, which is kind of interesting.
It is. Yeah. A lot of tradition.
I mean, where it's all kind of rooted in that. So interesting. I can't see either of you in the white wig, frankly, but it might be, at the costume party, perhaps. So before we start talking about work comp, I personally really enjoy legal shows, television, movies, things like that. And do you have a favorite? Is there one that so I'll give you some examples. I have this vision of you guys sipping the scotch at the end of the day, just like in that Boston Legal, the William Shatner. And is that reality or?
I actually have scotch in this right now.
Right. Okay. Is Randy your boss or just a counterpart?
We're partners now.
Do you have bosses?
No. I mean,
as a partner, you don't have a boss necessarily. There's a managing partner.
Right.
But you don't really have a boss. Okay.
We're really all accountable to one another. That's what partnership's about.
As the partnership.
Yeah.
Okay. Interesting. Well, that's nice.
So favorite shows, it hasn't been on for a long time, but when LA Law was on, probably before you were born.
Right. I remember that.
That was actually pretty technically accurate.
Was it?
Yeah. Other than, of course, real cases and real matters move very slowly.
Mm-hmm.
And when you've got an hour-long TV show, it's just not reality to, especially in some of these, to have like a crime, the investigation and a trial, and it's all done in 1 hour.
Yeah, literally, it probably spans a week total in the time frame.
Movie wise, A Few Good Men would be my favorite.
That's a good one.
Yeah.
Is that the Tom Cruise?
Right.
Jack Nicholson. Wow, that's powerful. That really is interesting.
My favorite is My Cousin Vinny. That's the reason I went to law school.
Is it truly?
I absolutely love the courtroom scenes in My Cousin Vinny.
Are they similar? I mean, have you had similar? I mean,
it's so dramatized,
just so absurd that it's
but it's not that absurd in the way he cross-examines witnesses.
Mm-hmm.
In fact, in one of my classes in law school, a trial advocacy class, they showed scenes from that, and they're like, "This is kind of a textbook cross-examination." Obviously, it's stylized. He gets away with some things you wouldn't in a real courtroom, but that's basically the framework of how to impeach somebody on the
That's
stand.
interesting. So it's not quite like the one of the movies I'm thinking of is Lincoln Lawyer.
Mm-hmm.
I don't know if that is a Grisham or a Michael Connelly or whatever that is.
I think that was Grisham.
But it's Matthew McConaughey, and he drives around in a Lincoln. Basically, his office is his car. Essentially, I think that's the concept. But it's very dramatic and stuff. And law is not necessarily always like that. I don't think, is it? I mean, is it?
No, a lot of it's pretty mundane.
Mm-hmm.
Quite
a lot
honestly.
of research.
A
lot of paperwork.
I mean, it's intellectually stimulating, but it's not flashy.
Mm-hmm.
I remember when my kids were little, there was some show, I think it was called Jag.
Oh, yeah.
And, this guy would, fly, the lawyer would fly jets and everything.
Right.
And my kids are little and they're asking me what I do.
Yeah.
And if I've ever flown a jet.
Yep. Do you fly a jet to work, Daddy?
No.
Yeah. Oh, no, that's awesome, though, man. I do find it really interesting. I don't know. There aren't a lot of like OSHA shows, but I would assume that it would be hard to not be really critical of a show of your profession when you watch it. You know, like that's crap. That never happens, that kind of thing. I think it would be. So maybe it's not as pleasurable to you living it every day as it would be to me or something.
Exactly. And when I say something like that, my wife just looks at me and says, it's a show.
Yeah. Right. Just go with it. Yeah, but it's hard to do. Well, let's talk a little bit about, first of all, the labor and employment practice at Baird Holm. What you guys cover a lot of ground there. OSHA law, workers' compensation issues, retaliation, discrimination, all sorts of things.
All of those. Yeah. I mean, pretty much every legal concern an employer could have, we've got it covered.
Okay.
Just because that's the way we've evolved over the last 150 years. I mean, we've, based on clients' needs, we get lawyers or train up lawyers to specialize in the areas of the law that they need to be on top of to give good representation to those clients. So, yeah, I mean, we do traditional labor relations, that's involving unions. We'll represent employers in terms of negotiating collective bargaining agreements, union elections, things like that. Employment law, which, as you mentioned, the discrimination claims.
That could be ADA issues, all of those are employment.
FMLA, and we do a lot of counseling and compliance. Now, Brian's practice is more litigation-based, where mine is more counseling and compliance-based, trying to help people, help employers stay out of court. And when I mess that up and they get in court, then Brian takes over.
Okay. Okay, here you go, buddy. Here's some notes I scribbled down, so good luck with that.
Exactly.
Yeah, but I can remember you and I have known each other a long time, since my OSHA days and early days. And we always used to think, oh, shit, they got Randy Stevenson. I can remember we would issue citations. Randy would come in, typically educate us because you had done your homework. Invariably, you knew more about the regulations than we did at that point. And you would slide some obscure letter of interpretation across the table to me or, to Darwin or whomever. And we
or
would
a review commission case.
Exactly. Yeah. Which really we didn't have a lot of access. I mean, we had access to them, but researching the review commission was difficult for me to just navigate that system. It was much more difficult, so usually you had, okay, vacate, whatever, reduce, reclassify. Please just leave me alone.
Yeah. Well, and you guys were always good to deal with. Everybody there has been, good to deal with. I've not really had anybody who is just a jerk for, sometimes they don't agree with us, and that's fine.
Sure.
But I think
that's okay.
You got a lot of folks there who are dedicated and just trying to do their job.
Yeah, ultimately.
Yeah.
And there need to be checks and balances in every system. Someone needs to hold OSHA accountable to its rules and regulations as well. So
exactly,
no hard feelings. And now we've become great friends, and we actually work together much more than we used to. So
yeah, it's been over 30 years.
It's been a long time, man.
So,
well, let's get the kid involved.
Okay.
So this work comp thing, I admittedly don't know a lot about workers' compensation. It's always been there on the periphery of what we do, but the system itself, can you describe just basically work comp? I mean, what it's for and why and
Sure.
those kind of things?
Yeah, I think there's a lot of misconceptions generally about workers' compensation. A lot of people think it's like a state-run system, almost like Social Security, and that's where the benefits are coming. And that's not the case. It's a state system, but the state requires every employer to have work comp insurance. And what that is insuring against is injuries in the workplace. And anytime you have an employee that gets injured in the scope of their employment, if it occurs in the course of employment, arising out of their employment, you need to pay benefits to that employee. And that'll come in different forms. Medical benefits and disability benefits are the big two.
Okay.
And really that medical benefits could be unlimited. If this person is severely injured, you're going to be paying a lot of medical, and anything they need that's reasonable and necessary as a result of that injury, the employer and their insurance company needs to pay those benefits.
Okay.
And the disability benefits are basically for the time you've lost from work. If you're off work, healing and treating, you're going to get temporary disability benefits. And after you finish treating, you're going to get any benefits related to a permanent disability. So if you've broke your leg and you're going to have that lack of mobility in your ankle the rest of your life, you're going to get compensated for that. If you've got permanent work restrictions that are going to limit your access to the labor market, you're going to get a loss of earning capacity in the form of permanent disability benefits.
Okay. So what does no fault mean?
Yeah, so it's a no fault system, and I think that's one of the big misconceptions is folks think, well, it was my employee's fault. He did something dumb.
Drove the forklift off the dock.
Exactly right. And they think, well, we shouldn't have to pay for that. It's his fault. It's a no fault system. And really the whole idea behind work comp is it's a trade-off from typical tort liability, where
would that be a lawsuit of some sort? Is that?
Yeah. So typically you'd need to prove who was at fault.
Okay.
You'd need to, if you slip and fall at the grocery store, you need to prove the grocery store was liable.
Okay.
If you're injured at work, you don't need to prove that they were liable. You just need to prove that it happened at work.
At work, in the scope of your work.
Right. And the trade-off there, it's easy to show entitlement to those benefits, but your benefits are capped. So you're not going to get pain and suffering damages like you would if you sued someone who is not your employer.
I see.
And so it limits the employer's exposure, but at the same time, it's a slam dunk when somebody gets hurt. Most of the time.
Interesting. And so I've always wondered then, why employers or maybe the insurance companies don't fight more cases. Is it because it's a slam dunk typically? The burden of proof is significant for the employer to demonstrate that it wasn't a work-related issue or something like that?
Yeah, that's exactly right. And the insurance company and the employer have an affirmative duty to pay those benefits if there's no dispute.
Okay.
And if they fail to do it within 30 days, they get penalties, and they can just make things worse for themselves.
I see.
And so In most cases, the insurance company ought to just pay the benefits and not fight it. Now, there's lots of reasons to fight it, and there's situations when you're going to want to fight it. But the run-of-the-mill work comp case is not going to result in a lawsuit and is not going to be disputed.
So how do you know if you need an attorney? I mean, when do you need an attorney? Because you don't have an attorney representing you for each work comp claim, I would assume. Is that
right?
Or do you? I don't know.
By the time the case comes to us, typically there has been something that's gone awry.
Okay.
Either it's disputed whether the injury actually arose out of employment. It might be, well, this person already had XYZ symptoms before the accident. I don't know that this accident caused these injuries or aggravated these injuries.
Someone may have suggested, well, I saw him do that playing softball this weekend or something. Maybe the factual representation is a little bit loose or something.
Yeah, we see a lot of that.
Yeah.
The other thing, when you talk about, the trade-off, and for the employer, the damages are capped. The other thing that's really good for the employer is if the claim occurred during the employee's work, workers' comp is the exclusive remedy. In other words, the employer can't pay out those benefits, and then the employee says, well, I'm going to bring a separate tort lawsuit against you too. That's it. And, if it's, I'll give you an example. A lot of times the benefits depend upon the person's, like for someone who dies, what kind of a family situation do they have? And I remember, and this was one that you guys at OSHA investigated when you were there, a guy who was working at a feedlot, young kid, he was like 19, 20 years old. A bull just moved around and crushed him, and
I remember
he died.
That. Yeah.
And the work comp payout was $6,000. That was the entire payout. It was just funeral expenses because the kid wasn't married, didn't have any children.
Wow.
So that it's really got a significant impact in some cases.
Had no duty to care for his parents or anything. So that was it. That would just, wow.
And then, you see other cases where someone passes and, they've got a big family and they may have had a lot of medical expenses before that. And, actually probably the most expensive cases, I would assume, Brian, are the ones where the person hasn't died, but really is significantly disabled for the rest of their life.
Oh yeah, that's exactly right. The most expensive ones are usually back injuries or maybe a head trauma or a traumatic brain injury where there's treatment ongoing for the rest of the person's life.
Yeah.
And if they're determined to be permanently, totally disabled and can't return to work, the employer is going to be paying benefits weekly for the rest of that person's life. So those are the most expensive. Where if it's a death benefits case, when their children reach the age where they're heading off to college and they're adults, those benefits stop.
It's over. Yeah.
Sometimes those are much shorter.
I think that's interesting. So different scenarios. I'm at work. I hurt something, strained my back, whatever. I go through some therapy. I'm unable to work. I have therapy. I get released to go back to work and everything's fine. And I get like perhaps a weekly benefit then during that period, but there is no settlement because there is no permanent disability. I go back to work and that's it. Your benefits would stop at that point and whatever that is.
Right. For the most part. So that the time you're off, the benefits are going to be, let's say you're completely off work for that period. Your benefits will be 2/3 of your average weekly wage. And that average weekly wage is determined based on your prior wages for 26 weeks. And so 2/3 of your wages, it's tax free. So it's essentially the same as what you'd be bringing home after taxes.
Okay. Is it capped at some level?
And there are caps, and the Work Comp Act updates that every single year. And so high wage earners are not going to be bringing home the same amount that they typically would when they're on the temporary benefits. But once you've reached what a doctor determines is maximum medical improvement, that's when we determine your entitlement to permanent benefits.
Okay.
And in the situation you're describing, if you come back to work and you have no permanent restrictions or impairments or anything, there's going to be no benefit.
There's no settlement.
Right.
Okay. Well, I guess the case is concluded, but you don't get a lump sum or something like that. This check or whatever, or a continuation of benefits. So I went to a place one time when I was a compliance officer. It was a food processing facility that'll remain nameless, but the employees, it was a union shop, and the employees, there was a job where there was a lot of manual cutting. Okay. The employees were making a cut on a piece of meat, and they were all, they had those vats full of like melted wax in the break room. This is probably predates you, but the employees would go in there and they would put this hot wax on their hands and wrists to give them a little bit of soothing relief, during their breaks. And then they would peel that wax off and go back to work. And as I'm walking through this facility with the plant manager, and we're talking about these employees. I was like, why don't, all of them had carpal tunnel surgeries of some sort. Why don't they move? Why don't you move them over to well, they want that job, and they all have settlement checks. Doug just got a new pickup, and Bob's got a bass boat, and Tom's got a camper. And I was flabbergasted by that, because, I'm a do the right thing guy. I believe, I didn't really even conceive that people would want, and maybe that's extreme, but they were willing to suffer that injury for that settlement. And so apparently they've had this carpal tunnel surgery. They received some kind of a disability decision by a physician, and they get some kind of settlement for that. Is that in the realm of possibility?
Yeah. I mean, I'm with you. I don't think I'm wanting to sell my right hand for a new truck, but
depends on the truck.
Yeah. I mean, a really nice one anymore, man. The trucks are expensive,
but yeah. So in the Work Comp Act, there are two different kinds of injuries. There are scheduled member injuries, and there are non-scheduled member injuries that we call body as a whole injuries. Okay. The scheduled members are things like
you're talking about members, meaning like a body part, not like a club.
Right. Yeah.
If you're in the club, you get a rate different than the guy that's not in the club.
Members only.
Right.
These benefits. No, things
you
like
lose
hands,
a finger, lose a hand,
fingers, arm, legs.
Okay.
And there's a schedule for what that body part is worth.
Okay.
And so it's a weeks of benefits.
I see.
So those types of injuries will be assessed by a physician and assigned a permanent impairment rating. And then your benefits are based off of that impairment rating. So if you've got, carpal tunnel surgery,
mm-hmm.
you heal up and the doctor says you've got a 10% permanent disability benefit, or a permanent impairment rather, then your permanent disability benefits will be 10% of your benefit rate, which was 2/3 of your average weekly wage. And you'll get that weekly.
For life?
No, based on the schedule. So,
okay.
So if it's an arm, it's 225 weeks, and all of it, every different body part has a different number of weeks associated.
And does that come as a lump sum then, or would that just come as a weekly payment, or what's the negotiation for this big lump sum thing?
Yeah. A lot of times when you're seeing a lump sum, it's the insurance company wants to close their file out, and they don't want to administer these weekly checks. And so they'll offer an employee a lump sum just to close it out in exchange for a release of any future benefits.
Okay.
That's certainly not required. No one has to agree to it. But anytime there is a settlement, it has to get approved by the work comp court. So there's a few more hoops to jump through. But typically that's what the insurance company wants to do, is just settle.
They just want to settle stuff, right?
Yeah. They just want to wrap it up.
Okay.
Get it off their books.
You guys counsel employers, typically that would be your client. What do they do? What do employers do wrong that you would prefer they don't do?
Well, one is, when it is an injury that first of all, it's going to be recorded in your 300 log.
Mhm.
It's going to be one that you've got to fill out a first report of injury for.
Okay.
I mean, the state statute for when it's necessary to fill out a first report of injury virtually mirrors what is a recordable injury for
Okay.
OSHA. And employers worry, well, if I do that, we're admitting liability, and you're really not. What you're doing is, you're following the law, because technically not filing a first report of injury is a minor crime.
Mm-hmm.
But second, you're starting the statute of limitations to, running. If you
Okay.
don't do that, then 5 years down the road, 10 years down the road, somebody can raise a claim.
I see. Okay. So we want a chronology on this, so we know there is a reporting time frame or something that's also for the employee. Is an employee obligated to report within a certain time frame, or?
Well, that I'll let you address that.
Right. So in order to be entitled to benefits, you have to give your employer notice of the accident and injury.
Okay.
But there's really no clear, bright line rule
Mhm.
for that. It's as soon as practicable. And so
Okay.
it's very fact dependent. But even if they don't give you notice, if you have knowledge of the accident and the injury, you'll be imputed with
Sure.
with the notice.
Of course. that is-
And so you can't turn a blind eye to it. And that's one of the mistakes I see employers make all the time is they know an employee has a nagging injury, or they've
Mhm.
left several times for medical appointments, and they do nothing to see whether or not it happened at work.
They haven't done a reasonable job of investigating that.
Right. And the court is going to assume you had knowledge if it's clear that you should have investigated and followed up to see whether this happened at work. And so you might as well investigate and
Yeah.
find out if it happened at work,
Mm-hmm.
because otherwise you've lost your opportunity to timely ask questions and investigate and find out what happened.
Okay.
And that employee's story can evolve, it can change. Witnesses might no longer work with you. A lot of things can go wrong. And so that's the biggest mistake I see employers make, is not investigating an accident, either when they don't, when notice isn't very clear, or when notice is clear and they still don't investigate it, which
Mhm.
blows me away.
Mhm.
You need to investigate it, and you need to have thorough investigations. I mean,
Mhm. And then when does that first report have to be filed based on that notification?
within 10
10
days.
days.
Within 10 days.
Yep.
Okay. To the court. Does that go to the court?
Right.
Okay. And
Yep.
you probably also notify your insurance carrier. Is that part of that notification?
Right.
Right. You should-
Okay.
there's really no reason not to
Okay.
file the first report and let your insurance company know.
Okay.
Another mistake I see clients make, employers make, is they don't realize that something can be deemed work related. And I'll give you a good example. There's a Nebraska Supreme Court case where this lady was working, and she had her 15 or 20-minute rest break, whatever it is. Excuse me. And she left the premises to go to like a quick shop or quick
Mhm.
convenience store to get a soda and for herself and some other employees, was coming back and slipped on the ice and injured herself. And I believe that she slipped and injured herself on the convenience store's property. And that's tough. I mean, if I'm an employer, I'd say, oh, that's too bad, but it didn't happen here.
Mhm.
But the Nebraska Supreme Court said that's compensable because she was on her break, and rest breaks are for the benefit of the employer because it refreshes the employee, makes them more productive. And even though it happened on someone else's premises, it really didn't matter.
Mhm.
It was still a compensable claim.
Mhm. Wow.
So, in terms of that, I would just say if it happens on your premises or while the person's working or while the person's, arriving at work or on break, it's not always that you have to record, but you might want to reach out to your legal counsel
Okay.
to figure out, okay, is this something that we need to file a first report on?
Okay.
And by the same token, record it in your 300 log.
Yes, that's something that would be recordable as well. It's interesting because at the very beginning of that 1904 regulation, the record keeping regulation, it does state that note, the two systems are not the same. If something is not compensable, it doesn't mean it's necessarily not recordable and vice versa. So they try to make that clear, but there seems to be a significant amount of overlap, obviously. I mean, the work environment. That one where you leave the premises for your break, that's an interesting one because that would not necessarily be the work environment as OSHA views it. You are outside of the work environment, but since you're still functioning on behalf of the employer, it could be compensable. That might be a tough one to swallow, man.
Yeah.
That'd be tough.
And employers have asked us, hey, write something up. We're going to have a firm outing, and I want you to write up a waiver. So they waive their work comp rights. And we can write it up, but at the end of the day, you can't waive your work comp rights. Well, remember, this came up during COVID.
Right.
If somebody out there got the boneheaded idea to say, oh, have your employees sign waivers that if they get COVID, it's not work related. Well, no, I mean, they can't waive their rights like that.
Mm-hmm.
I mean, the only way they can really waive the rights is in something approved by the workers' comp court.
Okay. Nice try. But what about voluntary participation? If it's still a company function and you are essentially coming because you want to rather than you're required to, does that make a difference or no?
It does, and it's again, it's pretty fact dependent, but is it for the benefit of the company? And so most of those sorts of team building activities.
I was going to say you could consider anything like that team building to some degree, probably.
Right. So the company softball game, that kind of thing, oftentimes is gonna be work comp. And that's a question I get a lot from employers where we went bowling and somebody had too much to drink and they blew out their knee, and you got to be careful when you're still in a work environment when it's a company sponsored event and you're strongly encouraging everyone to come because it's for the benefit of the team. Right. And so if there's going to be alcohol involved, you got to make sure people are drinking responsibly and
of course
being safe.
Should anyway, man. But
right.
That's interesting. So what other advice do you give your clients who are the employers? What kind of advice do you give them? Do you give them some when they retain you to do their work comp legal work? Do you give them training, advice, counsel? I mean, what do they need to know that makes your job easier on their behalf?
The number one thing that they can do to make our jobs easier is do a thorough investigation on the front end after the accident. And, that should include a written accident report that's been completed by the employee and a supervisor. If it's necessary to have witness statements, get statements from people who saw the accident. If there's surveillance, if you have a camera somewhere in the office space, make
that
sure
has probably changed things quite a bit.
Absolutely.
There seem to be cameras everywhere.
It has, but unfortunately, a lot of them after 30 days or 60 days record over themselves.
Oh, I see. Yeah.
And that wasn't captured.
I got you. Yeah.
So you want to make sure you're capturing that. Sometimes it's appropriate to take pictures of the area.
Just a thorough investigation, right? I mean,
right. Things you'd want to do.
You should do that for any accident.
Right. And there's a lot of reasons why that's going to benefit the company. One, if you're investigating how accidents are happening, you can prevent those accidents from happening, and you can make changes. You can also lock in the employee's story of what happened so that their version of events don't creep as we get towards litigation. A lot of times we'll see an accident report says one thing, and then their medical records, what they're telling the doctor, says a little bit more of an embellished version of the story.
Sure.
And then we take their deposition when it enters litigation, and there's an even more exaggerated version of the story. And if you haven't locked them in at the front end and got their signature on a accident report, we can't show that their story is evolving to fit their narrative.
Right. Interesting.
And so that's one other reason it's really important. Another reason is for their doctors, because oftentimes the dispute is a medical dispute. Is this injury really related to the accident that occurred at work?
I see.
Or is it personal in nature? Is it pre-existing? Is it the natural progression of that pre-existing injury? And so if your accident report clearly shows what symptoms they had at the time of the accident, what body parts they injured, and conversely, what body parts they didn't injure, you can provide that to an independent medical examiner and say, well, this is what they said happened. This is where their pain was. Does that make sense in your medical opinion that could evolve into what they're currently dealing with?
An independent medical examiner. So let's talk a little bit about, in Nebraska specifically, the employee can go to any doctor they want to, or do they have to go to a specific doctor if they haven't had an accident at work, for example? What is that?
Yeah, so that's an important piece. After the accident, employers are required to give the employee notice that they have a choice of physician.
Okay.
And if you fail to give the employee that notice, they can go to any physician, right? And so,
make that distinction. I'm not sure I understood that.
Right. So typically, the employer will provide what we call a Form 50, and we call it that because it's governed by Rule 50 of the Work Comp Court. And it's a choice of physician form, and they can choose a physician that they have a history of treatment with.
Okay, so they've established a relationship with.
Either their personal family doctor, or maybe their wife's, if their family has a treating relationship.
If the dude has an OB issue or something.
Right.
Sorry, we don't want to go down that road. My apologies.
But if they don't have an established treating physician, they're then subject to the employer's choice of physician.
Oh.
Or if they've received that notice and they decline to choose a physician, again, the employer can make that selection.
Okay.
And there's obviously a lot of advantages to that.
Sure.
And typically your insurance company will manage where they're recommending the employee go for treatment.
Your insurance company as the employer, the employer's insurance company will be giving some direction on selecting a physician.
Correct. And once
there seems to be an inherent bias in that, I would assume, right? I mean,
absolutely,
that's understandable.
Yeah, and an employee's family, primary treating physician is going to be more favorable.
Sure,
to that employee.
There's bias there as well, but they don't really have expertise in occupational medicine either. So there are some advantages to going through some type of an occupational medicine facility or with someone with expertise.
Exactly. With an aim at getting this person back to work as soon as possible.
Understanding that. Yeah.
But the other thing is, once the primary treating for the injury has been selected, the employee has to stay within their chain of referral. So if they're referring that employee out to specialists, they have to stay within that chain of referral. Where if you don't give the employee that choice of physician form and notice that they've got a choice of physician, they can go anywhere they want, and they don't have to stay within a chain of referral, and they can doctor shop.
Oh my gosh.
They don't hear what they what they liked at the first doctor. They can go to another one.
And their cousin Shecky says, "Oh, I got a guy."
Yeah.
Yeah.
Exactly. And ultimately that could all be compensable if you failed to give them that Form 50.
Paying for each of those doctor visits and assessments.
So long as they're reasonable and necessary to treat the injury. Right.
So that's a really critical step on the part of the employer, making sure that's communicated right away. When does that have to be communicated? At the time that that report is given, when the employee makes notification that I've had an incident, and you tell them if you plan to seek medical attention, you have to.
Right. It's before their first treatment, unless there's an emergency situation and they need to go to the ER.
Well, if the guy that goes home, has the injury, goes home, I'm going to, rub some dirt on it and see what happens, and then goes to a doctor on their own, as long as you've given them that notification? Could a doctor be disqualified then if they're seeking out medical assistance from someone they don't have a relationship with, or something like that?
Right. So if a doctor's been selected, you've given them notice, and a doctor's been selected, but then they go pick a different doctor, they can do that, but they're going to have to pay for it on their own.
Okay.
And the hazard for them is their insurance might not cover it because it's work related.
Interesting. Okay. So do you guys use, what if you suspect that the incident report is not factually accurate? I mean, do you ever go stake out the softball diamond, or do you have the people that might do those investigations? Does that exist, or is that
not as often as you'd think, but it does exist. And the insurance companies,
is it typically the insurance company driving that, or do they work for you as counsel?
They love it. It's fun. So the insurance companies, yes, they love surveillance. Personally, I think when you're doing surveillance, it's got to be really educated and thoughtful surveillance. You want to be going to the softball field when you know they're playing softball, for example, or we'll suggest having a private investigator follow them to their doctor's appointment, because then we can see they're walking in just fine. Then they tell the doctor, I have this limp and this altered gait, my back hurts, and then they drive away. We see them at the grocery store, and again, they're just fine.
Is that more of an exception than the rule, or is that, I guess, case by case?
Yeah, it's case by case, but I'd say it's more the exception.
And usually it's because the employer's been given some information by other employees.
Right. I hear that often. Yeah, that the employees are,
he's out on his
skeptical.
Boat.
Right.
Or here's, Facebook, and he's water skiing.
Right. Oh my gosh. The phone camera has changed things for you guys as well, hasn't it?
Yeah.
I mean,
of course, the response from the employee is, "Oh yeah, and I paid hell the next day for it."
Right. Yeah. I really wanted to get back to normal desperately.
That's right.
Interesting. So what's the biggest settlement I guess that's not a good thing for you.
What's your worst loss?
What's the worst?
Let's retract that.
77-0 against.
I remember that one. Yeah, so I guess that's not a good question for you. I was going to say, but
don't bring up wounds.
The ambulance chasers are always boasting about the big settlements and things like that. And I have been deposed a few times, and I don't consider myself an expert witness, but I've actually given opinions on certain things that had a safety component to them, and whether or not there was a violation. I think that was just useful information. But I can remember testifying it was an arbitration, actually. I guess it wasn't really a judge. It was a retired judge. He was an arbitrator, but it was I was speaking on behalf of the employee. The employee had been injured, chemical exposure, and the employer was Walmart. And so we were in a hotel in a little conference room, and there was me, the injured party, and his attorney, and like 24 Walmart attorneys. They had the front table of people, the back table of people, the people that stood there handing stuff around, And at the end of that, I think he made me cry like 3 times on that. It was just, it was brutal, I thought, it's really cut and dried, I mean, they hadn't lived up to the requirements of the regulation, in my opinion. But by the end of it, I thought, I'm going to be black and blue, It looked ugly. The attorney came up to me afterwards, the Walmart attorney came up and afterward and gave me his card and said, "Hey man, not so bad. You held up better than most," or something complimentary like that,
Yeah.
But do you do the litigation side of this? Do you enjoy the litigation piece?
That's why I enjoy doing what I do, is the litigation piece.
Is it?
So
you would be the guy beating me up on the stand, the Walmart guy.
Yeah. If you can make an expert cry, you've had a good day. Yeah.
Well, get me on the stand, man. I'm sensitive. Oh my gosh. I do remember though, I was on the other side of that. I was actually speaking on behalf of an employer who was a client of mine, and the attorney representing the, I guess that'd be the plaintiff, the employee, was asking me about my credentials. And so he was asking, I had a CIH and a CSP at the time, which are basic safety and health credentials, nothing fancy, but he was kind of like screwing with me a little bit, which I didn't appreciate. And so he was asking me, like, what's it take to get that CIH thing that you've got, And so I gave him some shit about, like, well, probably just like getting that law degree thing that you've got or whatever, But I could hear the judge go, "Oh shit," like, or whatever, So, but it wasn't an attack, but I guess your credibility plays a big part in your testimony. So I think he wanted to maybe undermine my credibility.
Absolutely.
Now, I was wearing the same T-shirt. I don't know why you had to go to those lengths to try to discredit me, But it does sound like the courtroom would be an interesting place.
Yeah, it's a lot of fun. It's one of the reasons I enjoy doing the work comp is, a lot of people know most lawsuits settle these days and don't ever end up into a courtroom, but the work comp cases move much quicker, and they do end up going to trial more often than the average litigation.
Okay.
So they're quicker cases. There's not as many witnesses typically. There's not as, it's not a week-long jury trial. They're typically one day, but you get into the court often, and that's the fun stuff for me.
And the depositions.
Those
are interesting. What are the rules of deposition? Are there rules? There don't seem to be rules.
Well, there are. And what's kind of fun is when you get a recalcitrant witness who won't answer your questions, then you have to get the judge on the phone.
Right. Interesting. Yeah, I've been deposed a number of times. And I must say the vast majority of attorneys that have deposed me on behalf of the other side have been very, respectful and, very professional. It's rare that anybody crosses any line that I've ever seen. It's always pretty low key and,
especially in this area. We've got such a professional bar in the Omaha and surrounding area that it's rare that we get in a fight at a deposition.
But do you know most of the attorneys that would be working on behalf of the employees?
Yeah,
you encounter them periodically.
Yeah, you a lot of repeat offenders for sure.
You see them again and again.
Yeah, absolutely.
Interesting.
Yeah.
Okay.
One thing I want to go back to when you talked about kind of the intersection between work comp and OSHA, Brian was mentioning the investigative report. I think whenever you've got a fatality or a really serious injury, that before you finalize that report and share it with the world, you run it by your legal counsel. I suggested that to a client once who was a pretty smart guy. And he said, "Well, why? It's like workers' comp is the exclusive remedy." I said, "Well, I don't want you to make any admissions in there, though, that OSHA is going to use to say,
right,
oh, wow, this was a willful. You admitted in here that you knew, this hazardous condition existed." So you have to be careful about what's in those reports. And a lot of times in fatalities and serious injuries, the safety personnel for an organization will fill those out. And I think they're almost taking personal responsibility. I could have done something better.
Yeah.
And
I agree.
That oftentimes, shows up somehow in that investigatory report, which is not good for OSHA purposes.
Yeah. But I have seen a number of safety people take that very personally. It's a very emotional time, obviously, and they do occasionally, even in that rapid response investigation where they are just sending information back and forth with OSHA. My advice is no adjectives. Like let's not make this more colorful than it needs to be. They get a little bit. But if somebody calls me and says, "Hey, we've had a fatality," my first question is, "Have you spoken with Randy yet?" Because I should not be your first call as a safety person. Speak to legal counsel first. And then if there's a need for some kind of safety assistance,
right.
But
yeah, because
I don't think
with
they should
legal counsel, you'll get that attorney-client privilege.
You just should not go into it without legal representation. The fatalities or serious injuries, what we used to call catastrophes, where there might be multiple people involved, things like that. It is kind of precarious.
Yeah,
I agree. And so what else? Any more advice
Well,
for employers?
The last thing I think for advice is after the accident, after you've done your investigation, after all the things we've talked about, what I see employers do too often is just kind of break off communication with their employees. It's with the insurance company and the adjusters handling it, and they're not communicating with their employees while they're off work. And that's a terrible idea. You need to continue to communicate with them, remind them that we're ready for you to come back to work when you're ready, and they'll come back, sooner and with a better attitude. You can easily alienate and disgruntle an employee if you aren't communicating with them, and they're at home and they're in pain, and they might start feeling like I'm disabled, and they're not going to come back to work as quickly.
And they might feel like abandoned. I mean, if you're not making that communication effort,
confused. And that's often when they go find a lawyer. And maybe I need a lawyer because I don't understand the system. I don't understand what's going on. Oftentimes too, there are things they can do. They can come in and do some work for you. And
does that disqualify their work comp?
Right. If they're
payment?
if they're working full time, they're not going to be getting a disability check.
Okay.
They might work shortened hours, and then you'll be paying them what we call temporary partial disability.
Okay.
And that can limit your exposure. You're going to be paying them one way or another. You might as well have them do some work.
Yeah.
And they're going to come back.
What's
sooner.
your opinion of that? That light duty that is just make work.
I'm not in favor of it. Brian says you're going to pay for it one way or the other. I mean, if you say I don't have light duty, go home. They'll get that, temporary disability indemnification. But I mean, if you don't have work for them, you don't have work. Now, it's not going to be dollar for dollar that you're paying for it. Your premiums will likely increase.
Right.
But the other thing too to keep in mind with this is, we often talk about the Bermuda Triangle, work comp being one part of it, but the Americans with Disabilities Act and the Family and Medical Leave Act also kick in here. And, so certainly, when somebody's got a work comp injury that takes them out, it's going to be deemed a serious health condition for FMLA purposes. And what I see a lot of employers, they just fail to recognize that. And no, it's FMLA. So give them the FMLA notice while they're out and start eating up that 12 weeks of job guarantee that they have under the FMLA. And the ADA kicks in because it's like, well, you're at MMI and you can't do your job. Guess we'll fire you. Well, time out. Is there a way we can accommodate the employee, reasonably accommodate the employee? And there may not be. But then the accommodation of last resort is always, okay, do we have another job this person is qualified to perform with or without an accommodation? Those are the steps you need to go through before you make that termination decision.
Okay. Well, that's interesting. I think, I guess, depending upon the employee-employer relationship, they're oftentimes quick to want to make that, to sever that relationship, and that may not always be appropriate.
May not be.
Okay, that's interesting. We are, unfortunately, over our time. This is really fascinating stuff. I enjoy the conversation very much. Thank you, Brian, for sharing a lot of that wisdom. I'd love to see you work in court, man. I bet it.
Just like your cousin Vinny.
Exactly. Just like, as long as I'm not the guy that's crying. And Randy, it's always good to see you, my friend. It's been a pleasure. You, first of all, congratulations to Baird Holm. I know you guys are celebrating your 150th anniversary, which is very exciting. Now, you weren't one of the founders, I'm assuming.
No, I came a couple years after it started.
Okay, right. One of the first round of hires, probably.
Yeah.
Good for you, man. Now, that's really cool. And you just received an accolade, an award, Lawyer of the Year.
I did.
I just saw that.
For employment law management side.
Good for you, man. I'm not surprised, but that's outstanding.
That's great. Yeah,
that is
thank
cool.
you.
And you've got a few years left in you.
I do.
Good.
Quite a few.
When you really?
Yeah.
You feel good and you're enjoying it still?
Yeah. I mean, the alternative is go home and bug my wife, and that's not going to go over very well.
No, right, man. Which is why I continue to work as well, right? Yeah, I have no intention of retiring, which, I enjoy the work so much. I just can't imagine not doing it. So thank you, fellows.
Thanks for having us.
Yeah, it's been my pleasure. Have a great weekend. Thanks for listening, everybody. If you need to get a hold of these guys, and you probably do, Baird Holm, BairdHolm.com, is that your
It is.
the website?
Mm-hmm.
I went on this morning, and there was a lot of great information on your website. You both have very nice pictures on the website, I will say. And all the contact information you need would be there at BairdHolm.com.
Right.
So give them a call. You probably need their help. You may not even know it. Thanks, everybody. Have a great weekend, and we will talk to you next Friday. Bye-bye.